morning. I want to talk to you briefly about the DWI law this morning. DWI, driving while impaired, is one of the most common serious traffic offenses existing at any time. In Oslo County alone, there will be 1,200 to 2,000 pending DWI cases at any given time. Being convicted of DWI doesn't make you a bad person or a criminal. It's just, it can happen to any one of us. It does happen to the best of us. But knowing something about the DWI law can help you in the future. The elements of the DWI law, as you might know, is pretty straightforward. You are guilty of driving while impaired if you are driving a vehicle in a street, highway, or vehicular area, public vehicular area within the state, and one of the following three conditions is satisfied at the same time. One, your blood alcohol concentration is 0.08 or above at any relevant time after the driving. Two, you are appreciably impaired due to an impairing substance. Three, you have any amount of Schedule 1 controlled substance. Of course, the most common source of impairment in a driving while impaired case is alcohol. So normally you get pulled over and you blow into an intoximeter and your reading is 0.08 above, you get charged with DWI. Now let's explore some of the defenses that we have in a DWI case. First, we challenge the traffic stop. We live in a free society. We have freedom from Fourth Amendment illegal searches and seizures. A police officer cannot just pull you over willy-nilly simply because they want to. They can pull you over only because there's a reasonable suspicion. We go to court and we examine the circumstances leading to the stop. Suppose you just weave a couple times in your own lane of travel. We argue to the court that based on the facts, there was no reasonable suspicion that you may have engaged in any criminal activity. If the judge agrees with us, the case is over, the case is closed, you go home scot-free. If the judge doesn't agree, with us, we go to the impairment prong. Suppose, in your case, you submitted to the intoximeter test, and the reading on the intoximeter is 0.08 or 0.09, not higher than that. That is a fertile battleground. Intoximeter is not infallible. No instrument is infallible. A space shuttle from NASA blows up. So when the reading on the intoximeter is 0.08, that doesn't mean that your actual blood alcohol concentration is 0.08. Your actual blood alcohol concentration might be as low as 0.06 or 0.07. We argue that to the judge. If the judge agrees with us, again, the case is defeated. In some cases, our client refuses to submit to an intoximeter test. We call that a refusal case. In a refusal case, the court looks to how the defendant performed on the standardized field sobriety test, such as horizontal gaze nystagmus test, walk and tone, or one-legged stand. We go to court and we emphasize and highlight how well our client did on some of those tests. And of course, we try to minimize some of the mistakes made by the client. And of course, these are not all the defenses, but just some of the defenses we explore. If you want to learn more about the DWI law and the defenses we use, please call your lawyer or contact any of the three lawyers at the Castle Law Firm. Thank you for watching. If you have any questions about family law or criminal law matters, please comment below or send us an email at castlelawfirmqa@gmail.com. That is castlelawfirmqa@gmail.com. Thank you for watching.